the Martin County School Board has violated state statutes and its own rules requiring equitable distribution of its construction contracts. In 2002, the county stopped its hard bid process and began using the construction manager at risk selection system to select CMRs for school board construction projects. Before 2002, when there was a hard bid process, we see no evidence of campaign contributions to school board members from construction companies who build schools and their subcontractors. During and after 2002, Urban will show that there was a dramatic inflow of campaign contributions to school board members from contractors who build schools, primarily Morganti Construction Company and Pirtle Construction Company. Urban will also show that from 2002 through 2009, Morganti and Pirtle received 74% of the school district's $265 million in construction work. The remaining 7 contractors who responded, and Your Honor, if I can interrupt myself, I'm assuming that you're familiar with terms like RFQ?
Yes.
Okay. The remaining,
but for the record, we may want to spell them out the first time you say them.
I will do that.
For the court reporter.
Sure. I've used the term CMRs, those are construction managers at risk, and I was about to use the term RFQs, which refers to requests for qualifications. The remaining, in addition to Morganti and Pirtle, 7 contractors responded at various times to RFQs. Those remaining 7 contractors who responded to RFQs received an average of 3.5% each of the school board's construction work. The school board was responsible for this inequitable distribution of work. Its first CMR contract selection back in 2002 for the construction of the Jensen Beach High School was protested successfully because the school board violated its rules and in the selection of its contractors. Since that time, in 2002, the school board has carefully changed its CMR selection format to give the school board virtually unbridled discretion in selecting its contractors for school board construction projects. No record of school board deliberations or the basis for its decisions can be found. So in this particular case, we don't know what the school board, we know what the school board did in selecting Pirtle number 1, but we don't know why they did it. Now, the evidence that we have compiled through the discovery process makes it fairly clear that some of the school board members did not understand what the statute requires. Some of them did not know what the school board criteria for selection of a CMR were. Some of them did not know what some of those criteria meant. Some of them did not understand how to apply these criteria to the selection process. There were a number of instances where misinformation was given to the school board in step 2 and in step 3 of the selection process when the 3 finalists presented, and the school board did nothing to back check its facts and had no information available between the presentation and the time of its decision, 20 minutes later, with which to ascertain whether or not the presenters were actually giving them truthful information. And Urban will show you 2 or 3 instances where Pirtle gave information that was misleading or false. There is some indication that the school board used what is called a step 2 fact scoring sheet and the criteria listed thereon, which are the criteria listed in the RFQ, as a basis for its selection. But we don't know that they did that. We do know that they didn't use, that some of them didn't use some of those factors, and some of them used factors that are not on the score sheet. And we don't know if they used point values or didn't use point values. And finally, Judge, the step 1 and step 2 process, which led us up to this point, which has significant value or significant importance in the selection of a contractor, were not held in the sunshine. So there are a number of things that were done in Step 1 and Step 2 by the PSAC, or Professional Services Advisory Committee, that we don't know about. We don't know what happened generally there. The actions of the school board over this number of years in changing its RFQ format and in changing the definition of terms in that RFQ format came to a head in 2009 when a gentleman named Julian Angel became the Director of Facilities for the Martin County School Board. When he stepped in May of 2009, he made some fairly significant changes in the way that the RFQ format used to be done. We've dealt with 3 RFQ formats in this circumstance. The first one, which was initiated in 2002, the second one, which was a March 1, 2005 format, and this third one, which is a July 28th, 2009 format. And the effect of that was to dilute the value of minority business-owned certification as required by statute, to subvert the factor of previous work granted to the persons who had previously received the most work, and to eliminate from consideration the local nature of the contractors. The final result of that, and in conclusion, Judge, is that the statute that requires the consideration of certain factors to the end of and with the objective of equitably distributing the work among qualified contractors, and the school board rule, which in effect tracks that same statute and requires the same result, or the same actions, have been ignored by the board, and it has acted with essentially unbridled discretion. And in this case, it gave an award to one of the people who have given board members campaign contributions when Urban was easily the most qualified local contractor and certified minority-owned contractor, and should have gotten this job.